Hello, I'm Professor Lucien Durvan. Welcome to Module 2 of my International Criminal Law course. For the students in the class, please ensure that you have downloaded the appropriate PowerPoint slides to follow along. And for everyone else, please enjoy our discussion of what crimes are international crimes and what are some basic principles of jurisdiction in the context of international crimes. Regarding the first issue, what crimes are international crimes? It is important in this context to understand the sources of the right and duty to suppress such crimes. We break these down into three categories: customary obligations, suppression treaties, and obligations emanating from the UN Security Council. By looking at each of these, we can learn more about where we should look to learn which crimes have been made international by the international community or by groups of nations. Under customary international law, states were supposed to be responsible for treating foreigners admitted to their territory in accordance with international standards of justice. Therefore, a state might incur liability for failing to abide by this customary standard. Other customary rules required states to suppress crimes against diplomats. As we saw in Module 1, there are examples of U.S. courts acting on these customary obligations. For example, in Peña Irila and Kiobel v. Royal Dutch Petroleum, the courts made reference to the 1784 prosecution by Pennsylvania of an assault on the French consul general. Another example is the 1887 case of U.S. v. Arjona, in which the defendant was charged with counterfeiting foreign currency. When the defendant challenged the law making this a crime, the Supreme Court upheld the statute on the basis of the United States' obligations to suppress this conduct under international customary law. Today, many of the customary international obligations have been converted into treaty obligations called suppression conventions, which brings us to our second category of obligation. Suppression conventions have become the dominant source of obligations to enact laws prescribing certain behavior. Early treaties with obligations to criminalize the behavior included the 1817 Additional Convention between Great Britain and Portugal for the prevention of the slave trade. Today, there are at least 267 multilateral treaties that require states to treat certain conduct as criminal. The types of crimes covered by the treaties include all manner of conduct, including aggression, genocide, crimes against humanity, war crimes, unlawful use of weapons, slavery, torture, apartheid, piracy, taking civilian hostages, unlawful trafficking in drugs, unlawful use of the mails, falsification and counterfeiting, and bribery of foreign officials. In dividing up the types of conduct that are required to be criminalized under these suppression treaties, there are three general categories that prove helpful and which divide the offenses up based on the degree of official involvement in the conduct constituting the crime. First, there are violations of international norms directed towards restraining the conduct of state officials acting under color of law. This would cover conventional war crimes, crimes against the peace, crimes against humanity, genocide, apartheid, disappearance, and torture. While these crimes don't necessarily require state action, they do involve the misuse of power. Second, there are crimes associated with terrorist activities. Here, the crimes will not typically be committed by the state. And third, there are crimes that are acts of private individuals that have been subjected to treaty prohibition because they involve either transnational traffic in illicit commodities or harm to a common or mutual interest of states, requiring international cooperation for its effective suppression. The final source of obligations we will focus on is the Security Council as a suppressor itself. For example, in Security Council Resolution 1373 of September 28, 2001, the Security Council responded to the September 11th attacks by stating the following, quote, "The Security Council decides that all states shall criminalize the willful provision or collection by any means, directly or indirectly, of funds by their nationals or in their territories, with the intention that the funds should be used, or in the knowledge that they are to be used, in order to carry out terrorist acts. The Security Council then used a monitoring committee to enforce the obligation. Thus, when we ask what crimes are international crimes, we must look to various sources to determine what has been captured by this term. The second topic for this module is to introduce some general principles of jurisdiction in the context of international crimes. We'll come back to ideas regarding jurisdiction in more detail in our next module. We begin our discussion for today by considering how extraterritorial jurisdiction is applied to U.S. statutes. When does the U.S. have jurisdiction to prosecute criminal conduct that occurs outside its borders? In answering this question, we must examine two related issues. First, whether a statute should be read as having extraterritorial effect, and second, whether international law permits the United States to apply its law to particular conduct. There are some statutes where it is clear that Congress intended the law to have extraterritorial effect. For example, the Foreign Corrupt Practices Act, which we will examine in depth in a later module, explicitly focuses on international bribery, rather than bribery occurring in the U.S. In other situations, however, courts are left to interpret the statute to decide whether it should be read to allow extraterritorial application. In trying to decide how to answer this question, courts look to various guides, including precedent, accepted jurisdictional bases, language from the restatement, treaties, and any relevant doctrines of law. An act of Congress ought never to be construed to violate the law of nations if any other possible construction remains would be one relevant doctrine of law. Another are rules regarding how to deal with inconsistencies between international agreement and domestic law, which is described in Section 115 of the Restatement Third of the Foreign Relations Law of the United States. The first case from the material today on jurisdiction in your textbook is U.S. v. Bowman, a Supreme Court case from 1922 focusing on the question of extraterritorial application of a statute. In 1920, the steamship Dio belonged to the United States. The United States also owned all the stock in the United States Shipping Board Emergency Fleet Corporation. The National Shipping Corporation agreed to operate and manage the Dio for the Fleet Corporation, and under the terms of the contract, the United States was responsible for paying for fuel, oil, labor, and materials used in the ship's operation. On a voyage to Rio, 4 individuals on the ship, 3 American and 1 British, hatched a plan to defraud the Fleet Corporation by pretending to buy 1,000 tons of fuel oil, but only actually taking receipt of 600 tons. Thereby, they could keep the extra funds that were supposedly used to pay for the larger quantity of fuel. The defendants were charged with presenting a false and fraudulent claim against the Fleet Corporation. The act was alleged to have occurred on the high seas, outside the jurisdiction of any district court in the United States, but within the Admiralty and Maritime jurisdiction of the United States. The remaining counts charged in the case were alleged to have occurred either at sea, in the city of Rio, or at the port of Rio. The defendants challenged the indictment, arguing that the offenses were not committed within the jurisdiction of the United States. The district court found that jurisdiction was lacking and sustained the defendants' demurrer. The lower court stated that Congress needed to expressly indicate that the charged statutes applied to ships of the United States on the high seas, but no such statements were present. The Supreme Court, however, disagreed. In its opinion, the court distinguishes between crimes against private individuals and property and crimes that are, quote, not logically dependent on their locality for the government's jurisdiction, end quote. The court went on to say, quote, if punishment of them is to be extended to include those committed outside of the strict territorial jurisdiction, it is natural for Congress to say so in the statute, and failure to do so will negative the purpose of Congress in this regard. But the same rule of interpretation should not be applied to criminal statutes which are, as a class, not logically dependent on their locality for the government's jurisdiction, but are enacted because of the right of the government to defend itself against obstruction or fraud wherever perpetrated, especially if committed by its own citizens, officers, or agents, end quote. In the second case in this section, Quintino v. United States, a Supreme Court case from 2005, The defendants were charged with wire fraud for smuggling liquor into Canada without paying the applicable Canadian taxes. The defendants moved to dismiss, claiming the U.S. government lacked sufficient interest in enforcing the tax laws of Canada, and therefore there was no wire fraud. In a 5-4 decision, the Supreme Court concluded that the scheme did constitute a violation of the wire fraud statute, despite the victim being a foreign country. The dissent in Quintino refers back to some of the traditional approaches to this issue in arguing against the court's decision. Quote, construing Section 1343 to encompass violations of foreign revenue laws, the court ignores the absence of anything signaling Congress's intent to give the statute such an extraordinary extraterritorial effect. It is a long-standing principle of American law that Congress, in most of its legislative endeavors, is primarily concerned with domestic conditions. Absent a clear statement of the affirmative intention of Congress, this court ordinarily does not read statutes to reach conduct that is the primary concern of a foreign country, end quote. The second part of our introduction to some general principles of jurisdiction in the context of international crimes focuses on jurisdictional categories. This section deals with the second question we started with when discussing jurisdiction, that being whether international law permits the U.S. to apply its law to particular conduct outside the national territory. The case here from your text, United States v. Layton, deals with the killing of Congressman Leo Ryan at the Jonestown settlement by followers of Jim Jones. Congressman Ryan had traveled to the settlement in Guyana to investigate allegations of mistreatment of residents and poor living conditions generally. When he was departing the settlement with numerous members of the settlement who wanted to leave, the group was attacked. Ryan and others were killed. Many of the residents of Jonestown then committed mass suicide. In total, almost 1,000 people died. The defendant in this case was apprehended by authorities in Guyana and transported to the United States for prosecution. He was charged with counts relating to the murder of Congressman Ryan and counts related to the attempted murder of the United States Deputy Chief of Mission in Guyana, a protected person under international law. Layton challenged his conviction on the grounds that the United States did not have jurisdiction in the matter. The court concluded first that jurisdiction was proper for the killing of Congressman Ryan because the killing of a member of Congress is, quote, directly injurious to the government, end quote, and the locus of the conduct is not relevant. This language should remind you of the holding in our case from earlier, U.S. v. Bowman. The court concluded second that jurisdiction for the attempted killing of the Deputy Chief of Mission was proper because the applicable statute was passed to, quote, fulfill the obligations of the United States under 2 treaties, end quote, regarding the prevention and punishment of terrorism and crimes against internationally protected persons. Specifically, one of the treaties called for the criminalization of such acts when the alleged offender was a national of the member state or where the crime was committed against an internationally protected person who enjoys such status by virtue of the functions being exercised on behalf of a member state. As Layton was a U.S. citizen and the deputy chief was an internationally protected person, the court concluded that jurisdiction was proper even though the act occurred outside the United States. This is a good case to end this module with because it returns us to a couple of the sources of international law we discussed at the beginning of this segment. Before we finish, let me mention something you might go back and review before starting our next module. In Note 2, after the case, one finds a paragraph from the District Court ruling in Layton, which describes the 5 traditional bases for international jurisdiction. 1, territorial jurisdiction, based on the location where the alleged crime was committed. 2, nationality of the offender. 3, passive jurisdiction, based on the nationality of the victim. 4, protective jurisdiction, based on the protection of the interests and integrity of the nation. And 5, universal jurisdiction, applicable to certain crimes where custody of the offense, or the offender rather, is sufficient. We'll be focusing on these in our next module, and this short paragraph serves as a great introduction to those materials as you begin to look forward. Thank you for joining us, and we'll see you for our next module in this course.